Welcome to the OK Let's Learn podcast. This is two podcasts in one where we dive into tons of interesting topics, and another where we dive into tons of family-friendly books and stories. My name is Kevin O'Keefe. So today, let's learn all about the United States Bill of Rights. Yes. Is it part of the Constitution? Is it not part of the Constitution? Why do they call them amendments? And let's go through each of them. How many are there, by the way? How many did they originally want? And how many amendments are there today? Okay, let's learn. Number one, what is it? When was it created? Hey, it was created in 1789. 2 years after the Constitution that was created in 1787. What's the Constitution? The Constitution is the oldest written document used still today. And what is it? It is a piece of paper that lays out exactly how our government is run. It is the law of the land. When you're looking at the rules for how our government should be set up, how it should be running, and what are the circumstances behind how our country is set up. That's the Constitution. Well, what about the rights of individual people? That became the sticking point with ratifying the Constitution right up front because people disagreed. Wait a minute. People worried that the new federal government would eventually become too powerful, just like the British government and the king that they had just replaced. So, what they decided to do was create the Constitution, ratify the Constitution, but only with the understanding that immediately following, they would give individual rights to people. A lot of the early framers of the Constitution said, no, we're putting in writing the limits of the government, so there's no reason to put in writing the individual rights that are guaranteed by the people. And too many people argued, I hear you, but guess what? That's not enough. We have to put it in writing because governments have been seen since the beginning of time, when organizations have been set up to rule over people, that they have abused their power. So if you put it in writing that all people in our government is set up for the will of the people, right? So if you put it in writing, everyone will be secure in knowing that they have these rights. That was the origin of the U.S. Bill of Rights. You really have to think of it this way. The Constitution created the government. The Bill of Rights told the government, hey, there's certain things you're simply not allowed to do to us, the people. Are they amendments? This is what is confusing. Wait a minute, I thought they were created together. Well, like I said, the Bill of Rights and the Constitution were not created together. So technically, that's why the Bill of Rights are considered amendments. Amendments are changes. And we have the Bill of Rights are 10, the first 10 amendments to the Constitution. And how about this up front? Who are the most important people of our founding fathers to make sure that the Bill of Rights became a reality? Yes. If you're thinking James Madison, you're right. He put together all of the individual rights with collaboration and pushing forward. It was Thomas Jefferson. But guess what? There's another founding father that is not appreciated as much as he should be, and that was George Mason. He up front started this whole process with the Bill of Rights because he said he wouldn't support the Constitution unless the Bill of Rights was included. And why? Because he had written the Virginia Declaration of Rights prior to this time period. And also Patrick Henry, he was another big supporter. So there were plenty of people that were influential. And I will say this up front, Alexander Hamilton, so celebrated today, he was originally against it. Not because he didn't want people to have rights, but he believed the way the Constitution was set up, like I said earlier, was that the federal government, through this document, the Constitution, only possessed specific powers. And basically that meant that it couldn't restrict individual liberties in the first place. But again, this is semantics. This is just, the point was, it was just too convoluted. We needed to have it in writing. Now, a little correction, I had mentioned 1789. That's when they introduced it to Congress, and Congress passed it, but it still needed to be ratified by the states. And that didn't happen until 2 years later. It was ratified on December 15th, 1791. And yes, December 15th is known as the Bill of Rights Day. Okay, let's talk about the Bill of Rights. And what's interesting is they are not called the first right, the second right. That would seem logical, right? Well, what they did, and this is understandable right here, right from the beginning, they call them the First Amendment, the Second Amendment. Why? Because each amendment, each change to the original Constitution, each right, includes more than one right. The First Amendment includes 5 rights. So when we talk about the individual rights, we talk about them as 10 distinct different amendments. And listen to this. The First Amendment has 5 distinct different rights. You have the freedom of speech. You have the freedom of religion. You have the freedom of having a press. Freedom also of assembling. And also the freedom to petition the government. Let's just dive briefly into each one. Religion. The bottom line is people can practice their own religion, and Congress cannot establish a quote-unquote official religion. Freedom of speech. Obviously, that means that people can say whatever they want. Even, obviously, talking bad about our leaders. I mean, you can't do that in other countries, right? It's so fundamental to people say, what is the most basic rights that we have here in the United States? That's the top of the list, right? There are limitations, and we will get into, for each amendment going forward, the particular court cases that solidified or made sure that everyone understood what the freedom of speech is. But the other one is that you have press. You have people that can report freely on what is going on here in our country and behind closed walls in the government. The press is allowed to report. Press being people that write in magazines, obviously, on the internet, websites, newspapers, etc. People can gather peacefully. In early democracies, this became an issue that a lot of people talked about. Say, well, wait a minute. When you have power vested in the people, it can get unruly, and too many people don't know enough. This was so often the reasons why people would say, no, you can't have democracy. Well, guess what? People can gather peacefully. It's allowed. And finally, people can petition the government to fix problems, meaning say, hey, listen, we have these issues and you need to listen to us. That is an inherent right. Okay, what was 2 Supreme Court cases that solidified or made clearer this right towards free speech? Well, it was Schenck versus the United States in 1919. Charles Schenck, he distributed leaflets urging men to not go into the military draft, resist the draft. Well, the Supreme Court ruled against him. Basically, the Supreme Court said, you know what, some speech could be limited during wartime if it created, quote, a clear and present danger, unquote. Those 4 words are often used to cite, what are some things you can't say? And obviously this, you can interpret it to mean, hey, listen, we're not going to be a country here if in fact we're going against our own government. But still, people will argue about that today because you are able to speak up against the government. But he used Justice Oliver Wendell Holmes. He used a famous analogy that we all know. If you don't know, you need to know this. When can free speech be limited? Well, guess what? If you go into a crowded movie theater and yell fire when you know that that is not the truth, that's causing panic. That can hurt people. People can literally be injured or conceivably pass away. No, you can't do that. The Second Amendment, the right of people to keep and bear arms, meaning weapons, guns, etc. For many years, the courts debated whether this protected, in fact, state militias or individual citizens, because unfortunately, as most court cases, when you dive into the weeds enough, what you find out is the actual written words in the original Bill of Rights, and this goes for the Constitution, can be confusing. What was its purpose? What do the words actually mean? So in the District of Columbia versus Heller in 2008, the Supreme Court ruled that individuals have a constitutional right to possess firearms for lawful purposes such as self-defense in the home. The court also had said that yes, there's reasonable regulations that still may be constitutional, and this is something that will be, no doubt, still argued so much into the future, has always been argued, because again, you can understand why this is so controversial. A lot of people feel strongly one way and feel strongly another way about the ability of people to maintain and bear arms. The Third Amendment. Soldiers cannot be housed in private homes during peacetime without the owner's permission. This was all about something that, no, you don't have a reality today. It was called the Quartering Act. And initially, this was when the Redcoats were allowed to stay in private facilities. No, believe it or not, a lot of people said that Redcoats initially, they would just knock on the door of a private home and say, no, I'm living here. And this was outrageous. It wasn't private homes, but it was privately owned inns, alehouses, barns, and even uninhabited buildings, empty buildings, but they were still privately owned. So the fact that this could be a reality, they wanted to make sure, no, forget it. If it's privately held, you can't force soldiers to live in homes, again, buildings that the government doesn't specifically own. And talk about the Third Amendment never being spoken about. There was very little, if any, court cases that came to the Supreme Court because it never became a reality. This was something that was held over from the Revolutionary War, and the constitutional framers said, no, we can't have this be anywhere close to being a reality again. The Fourth Amendment. It protects people from unreasonable search and seizures. Generally speaking, police need a warrant based on what we call probable cause before searching your home. The police just can't come in and say, you know what, you did this, we are searching your house. The landmark case that solidified this was Mapp versus Ohio in 1961. The Supreme Court ruled that evidence that was obtained through unconstitutional search and seizure cannot be used in court. This became known as, quote, the exclusionary rule. The Fifth Amendment. This contains several different protections, and this is why so often people can't rattle off all the amendments because, like I said, there's more than one right included in it. The Fifth Amendment is all about dealing with our legal system. You have the right to remain silent. You are protected against double jeopardy. You have the right to due process, and you have the right to a grand jury. Let's dive into each one of these, 4 of them. I plead the Fifth. You may have heard this. When you say, I plead the Fifth, you have the right to remain silent. You can't be forced to testify against yourself or answer police questions that make you look guilty. Interesting one, right? And it can get kind of confusing. You're protected against double jeopardy. What this means is that you cannot be put on trial twice for the exact same crime if you were already found not guilty. Very interesting. You're given the right to due process. What does that mean? The government must follow strict, fair, and established legal steps, procedures before it can take away your life, your liberty, and your property. There's rules regarding how you're brought to justice, right? And then finally, what's a grand jury? You have a right to a grand jury. Well, for serious federal crimes, remember, this is everything we're talking about here are for the federal government. And we'll get into this later with the states. For serious federal crimes, a group of regular citizens must look at the evidence. A grand jury, a jury of peers. They must look at the evidence first to decide if there's enough proof to even charge you with the crime. And finally, I was mistaken. There's actually 5 here in the Fifth Amendment. That's easy to remember. 5 rights with the Fifth Amendment. You have, they call it just compensation for property. What that means is the government cannot take your private land for public use without paying you a completely fair price for it. They call this eminent domain, right? The government can come in, right, and take your property. Well, guess what? They have to be fair in compensating you for your own property. What was the famous court case that solidified the Fifth Amendment? Oh boy, I think we all know this. The police, they first arrest you. What do they say? You have the right to remain silent. This all became reality with your Miranda rights. And where did this come from? It was a court case, Miranda versus Arizona in 1966. Police must inform you if you're a suspect of your constitutional right before they start asking you questions. Talk about a great individual court case that made one of these rights very clear. The Sixth Amendment. Yeah, you're right. It has 6 individual rights. A good way to remember this. When I'm diving into this, you could say that they have 7 rights included in the Sixth Amendment, but no. Most constitutional scholars believe it's 6 rights. One of them combines 2 rights, so if you want to nitpick, maybe it's got 7 rights. But here, let me lay out the 6 rights that you have in the Sixth Amendment. And here's another interesting and good way to remember all these amendments. The Fifth Amendment is all about your rights prior to a trial, and the Sixth Amendment is all about your rights during a trial. This, you could argue that, no, that's not a good way to explain it, but it is practically, you can come down on the fact that, yes, 5 and 6 is all about your rights when you're accused of something, right? So when you're accused of something, ultimately it's when it first starts, and to have justice, you go all the way through a court case. So, Sixth Amendment. What are the individual 6 rights? You have a right to a speedy trial. 2, you have a right to a public trial. 3, you have a right to an impartial jury. 4, you have the right to know the charges against you. 5, you have rights that concern the witnesses, and we'll get into that one. That's the one that you could say there's 2 rights in it. And then finally, the 6th right, you have a right to an attorney. A speedy trial. The government can't leave you waiting indefinitely before bringing the case to court. And this becomes problematic because, talk about the letter of the law and then reality. Unfortunately, if you don't have enough, supply and demand, you don't have enough judges and you have too many court cases. This is unfortunately what's happening too often in our country, that too many people have to wait too long before brought into a courtroom. You have a right, number two, the right to a public trial. That means your trial is generally open to the public, so you have transparency and you have fairness. You have a right to an impartial jury. What does that mean? Well, your case must be decided by a fair and unbiased jury. So when they select people in your case, they go through it methodically to make sure as best as you can that the people that are sitting in judgment of you are impartial. Impartial meaning they don't think one way or another. They're open to listening to the evidence presented, right? Fourth, you have the right to know the charges against you, right? Common sense. You have the right to be told exactly what crime you're accused of committing. They can't just say, no, hey, you're arrested. Why? Well, here's what you're charged with, right? You can't just, I don't like the way you look. And unfortunately, all these rights seem like common sense, and they are, right? But that's why they still need to be put in writing. The witnesses. This is one that you can say, well, it's two rights. You have the right to be able to confront witnesses testifying against you, and you also have the right to require the witnesses to testify on your behalf. So when I say confront and cross-examine, basically question the witness once they're in court. And the other right is, guess what? You can get witnesses to come into court to help you with your case, right? So finally, the right to an attorney. Again, too many people, attorneys and lawyers, they cost money. And a lot of people don't have the money. So you are given the right to be represented by a lawyer if you can't afford a lawyer. And certainly, and this is the case when when the case is such that you could be put into prison, a lawyer will be appointed for you, a court-appointed lawyer. And this was probably the most famous case that came out of the Sixth Amendment. It was Gideon versus Wainwright, 1963. Clarence Gideon, he couldn't afford a lawyer. So the Supreme Court ruled that states must provide attorneys for defendants charged with serious crimes who couldn't afford one. All right, the Seventh Amendment. It protects the right to a jury trial in most civil lawsuits. What's a civil lawsuit? Well, it's a dispute and argument between people or organizations rather than just you being accused of a crime. So yes, you can have a jury, right, be brought forth just because there's a disagreement. And listen, fairness is fairness. So you're allowed that right to have a jury decide what is a dispute, how it needs to be settled between two people or two organizations, right? And the Seventh Amendment, very rarely do Supreme Courts have they weighed in on the Seventh Amendment. Why? Because most arguments end up being settled before they ultimately went to trial. The Eighth Amendment, it protects against excessive bail, excessive fines, and cruel and unusual punishment. Three rights: excessive bail. Courts cannot set unreasonable high amount of money just to keep someone in jail before a trial. And again, this is why judges are here. This is why we have protections. Excessive fines. Government cannot charge you a lot of money that is kind of like really not fair based on what you're being charged for. And the unusual punishment, the cruel and unusual punishment, again, makes sense. Punishments cannot be over the top, unfair punishment based on what the crime was. An interesting Supreme Court case on this was in 1972, was Furman versus Georgia. And listen to this, the Supreme Court temporarily halted the death penalty. Why? Because states were applying it inconsistently and just differently across the board. Some states were more harsh than other states. And, why is this fair? You can think about this, right? Just because you happen to live in a certain state. But later states revised their laws and capital punishment resumed under another court case, which was Gregg versus Georgia in 1976. The Ninth Amendment. It's one of the shortest and it's one of the most mysterious. It says just because certain rights are listed in the Constitution does not mean people have no other rights. Interesting. The framers understood that they could never write down every liberty people possess. And that makes sense. One court case that is attributed to the Ninth Amendment was Griswold versus Connecticut in 1965. And the court basically said, hey, the court recognized that when you're married, right, you have a constitutional right to some type of privacy. But again, so much of this is a slippery slope. But here's the point, that if it's not written, doesn't mean that you don't have this right. And finally, the 10th Amendment is really an important one. Any powers not given to the federal government and not prohibited to the states belong to the states or to the people. This, no doubt, can be a future episode and talk about the difference of governments throughout the world. This reflects the principle of federalism. And here's the reality of our country. We know this. This entire list of rights is all coming from our federal government in Washington, D.C., right? Over and above all the individual 50 state rights. Well, guess what, though? States have powers, too. So federalism is the sharing of power between our national government and the states. One of the landmark cases that reflected this was New York against the United States just recently here in 1992. Supreme Court ruled that Congress cannot require states to carry out federal regulatory programs so that reinforce the limits on federal power over state governments. Right from the beginning, there was this push and pull, and there still is obviously today, between what is a state right, what is a federal right, to what extent can the federal government dictate rules over the states. So no question, the 10th Amendment is an important one. All right, to wrap up our podcast, here are some questions you may have been thinking about. What percentage of the states must ratify a constitutional amendment? 3/4, 75% of the states. So that means basically today, 38 states, if you bring forth an amendment, a change to the Constitution, 38 states have to approve it. Back when it was initially set up, right, 1791, there were only 13 states, so 10 states had to ratify the Constitution. What percentage of Congress must approve the amendment before it goes to the states? Well, here's an interesting one. First, 2/3 of the House have to approve it. Second, 2/3 of the Senate needs to approve it. And then, yes, 3/4 of the states have to ratify it. Fun fact, originally, there were 12 proposed amendments to the states. 2 of them were shut down. What was one of them? Well, an amendment was put forth that would create a formula for determining the size of the House of Representatives as the population grew. Guess what? I mentioned it was never ratified, but it's still technically pending. because Congress never did, excuse me, the Congress did not set a deadline as to when the amendment needed to be ratified or not. So it's out there still. And the second proposed amendment that was not ratified said that any law changing the salaries of members of Congress could not take effect until after the next election for the House of Representatives. So, believe it or not, how about this story? 200 years later, finally, there were enough additional states that ratified it. In 1992, it officially became the 27th Amendment to the Constitution. Talk about an unusual story. It took 202 years to be ratified. How many total amendments are there today? And just remember, all these amendments, they are not known as the Bill of Rights. You say, what are the Bill of Rights? They are the first 10 amendments to the Constitution. But how many total amendments are there? Well, 27, right? 17 have been added since 1791. Some of the most famous, and talk about future episodes, some of the most famous amendments were the 13th, it abolished slavery. 14th, guaranteed equal protection of all of our laws. 15th, it protected the voting rights regardless of race. The 19th, it gave women the right to vote. The 22nd, it limited presidents to 2 elected terms. The 26th, it lowered the voting age to 18. And the 27th, the constitutional, like I mentioned, the constitutional pay amendment that took obviously 2 centuries to be ratified. So those are just some of them. No doubts, like I said, future episodes. And how about this question? How many amendments have been proposed? Have they actually tracked this? Well, 11,000. There's been 11,000 constitutional amendments that have been brought forth in Congress. Only 33 have ever received the required 2/3 vote in both houses and been sent to the states. Of those 33, only 27, like I said, have been ratified and became part of the Constitution. Interesting, right? 11,000 proposed constitutional amendments. And what are just a couple of those that, through the years of those 11,000, that never got ratified and almost made it to the finish line? Well, one of them was the Equal Rights Amendment. It was intended to guarantee that men and women would have equal rights under the law. Of course, simple, right? But although many Americans supported that goal, people that were against it thought that it would have unintended consequences, legal consequences, that the consequences that affected laws regarding military service, laws that regarded the family, and that's why it ultimately didn't make it to the finish line. And another one is the fact that a lot of people in our country want us to have a balanced budget amendment, which basically means we can't spend more money than we have. Hey, that's a simple way of putting it, but it's a lot more complicated than that. Our 10 amendments, what's a good way to remember them? Clearly, there's a lot. It's a lot more than 10, right? We went into those details. So up front, you want to be smart, and people can argue about this, but how many rights do we have in the Bill of Rights? 26. Yes, 26. Remember that. And what's a good way to remember? Again, each amendment. First Amendment is all about our freedoms. Second Amendment, all about our weapons. Third Amendment, all about our home. Fourth Amendment, all about our privacy. The Fifth, the Sixth, the Seventh, and the Eighth Amendments are all about our rights in court. The Ninth Amendment, all the other rights, and the 10th Amendment, the state rights. So, the entire Bill of Rights can be remembered in just 7 ideas: freedoms, weapons, home, privacy, fair legal process, other rights, and state rights. If you can remember just 7 words, you can remember the entire Bill of Rights. 26 individual rights, but they're broken down into freedoms, weapons, home, privacy, courtroom, other rights, and state rights. Friends, I hope you've enjoyed this journey. It's been a long one, but it required a long podcast all about the United States Bill of Rights. Reach out to me at kevmok21@gmail.com. We are on Facebook. We are on YouTube. We are on X. We are out on most podcast platforms, the big ones being Spotify, Overcast. Heck, there's so many of them. But please subscribe. Please rate and review the podcast. And until next time, have fun and keep learning.